siento mucho que no es posible para mí hablar español. Tampoco sono lento, ma es troppo complicado para mí en este momento de hablar español. Confundo las palabras con las palabras italianas, que lo so mejor. So this is why I will speak in English, and I will stand up to show you how a typical lecture in German would be. Professors usually walk around and speak to the students and ask them questions. So be afraid in the first row. I won't ask questions, and I'll point to you when I want the next slide. Is that okay? Okay. So I'm really happy to be here, and it's a rare occasion that somebody can speak about didactics or the way we teach law in Germany, because teaching law usually is done. It's not being taught about, you do it. Legal education is something that is present in every legal system, and every legal system has their own style, but you rarely talk about it. We talk about content. This morning we had a very nice conference on procedural law, on the law of evidence, on the standard of proof, for instance, but we do not talk about didactics. So I'm really happy to have an occasion here to do just that. And it's even more interesting because the style in German is quite distinct, and I will have roughly 3 sections in my presentation. I will first give a brief introduction about the law study in Germany, and the second part, which will be the main part, will be then devoted to the Gutachten, Sachverhalt und Lösung, and the distinct Gutachtenstil, so the style and the way we ask our students to write the exam papers. And this is all linked, so this is because this is the reason I will have an introduction into the law studies in Germany, because the state exam we have is the reason for the Gutachtenstil, it's linked. And the third part will be very brief, it will be on the shortcomings of the system and possible reforms. And we'll have Q&A session afterwards. So, the basic assumption in Germany is that we have something called Einheitsjurist. So every law student aspires to be on the same level of education. Einheitsjurist means we do not have different tracks, career tracks. We have one career track. You have to write 2 state exams, and if you pass the second state exam, you are what we call Volljurist. So it's hard to translate, but it's a different state of mind, so to say. With the second state exam, you can be any legal type of job there is. You can aspire to be a judge or a lawyer or notary public or whatever you want. Without this degree, you are nothing, basically. So you must have the second state exam. Einheitsjurist. There is no special education for lawyers or for attorneys and so forth. And interestingly, the role model is not what would be statistically more viable attorneys, because more than 90% of all lawyers in Germany, and this is, I think, not very atypical. It's better to. Okay. 90% of all lawyers will be attorneys, so practicing law. However, the role model of the legal education in Germany is the judge. And this makes sense because the perspective also of a practicing lawyer and attorney will be, if he appears in court, what the judge thinks and how the judge would solve a case. So an attorney will think like a judge and present the case before the court like a judge wants to hear it. So it makes sense. However, of course, of these 90% of the lawyers who will be practicing lawyers, attorneys, not everybody will be forensic lawyers. Some of them will do M&A transactions or whatever else. They will just consult. They will not appear before court. They will never see a judge. And still, we have this one role model of the judge. And the legal basis for our education is not in a law called legal education law or something like that, but in the Deutsches Richtergesetz, so the law on the judge and the office of the judge. And there are a few paragraphs in this law on the federal level as to what we expect from our law students. So the curriculum, the basic contents of the curriculum are on the federal level. So the first part, the first state exam, or erste juristische Prüfung as it is called, is administered by the law faculties. So the law faculties are in charge for the legal education. However, the first legal examination is at least for 70% of the overall grade in the hands of the state. So the law faculties do the education, the legal education, and the state poses the questions. And this is one of the reasons for what we call the Volljurist or the Einheitsjurist. So the state grants the certificate, the state is responsible for the results, and the education is in the hand of the law faculties. 30% of the overall grade is in the hands of the universities. This is a reform that was introduced in 2008, 9 or something like that. It was designed to give the universities more flexibility, more freedom, more academic input into the whole system, but still the state examination comes. That's what is important. It comes at the very end of the studies after 4.5, 5 years. And I will talk about this in a second. This is the benchmark, right? So what comes before the university examination, this is something you do in between. It's not that important. What counts is the state exam. The state examination, I'm only talking about the first state examination. The second is a bit different. That's at the end of the practical legal education, Referendariat. The first state examination consists of a written part and an oral part. And again, the written part is the most difficult one, the most demanding one, and the most feared part of the exam. It lies within the responsibility of the federal states. So it's one level down. We have 16 federal states in Germany, and as the federal states are responsible for legal affairs, they are responsible for the administration of the state exam. So we have 16 different models. They are slightly different, but they are fully within the responsibility of the federal state. What is common is denominated in the judges' law. So everybody sits exams, and within one federal state, the exam questions will be the same. So in the state where I'm from, Baden-Württemberg in the southwest, we have 5 law faculties and about 1,000 law students per year who pass this exam, and they all sit the same exam questions, which makes the system comparable. You know exactly the ranking from number 1 to number 1,000. You can have an exact ranking, and you know who is the best. And so it's very transparent. The university examination is within the hands of the faculties. I said that already. So there are great differences also within the grades. Cannot really compare them. And this is why they are, I'm not saying irrelevant, but less relevant than the state part, because the state part is comparable and transparent, while it's totally intransparent. The contents of, say, the subject in criminology or labor law, there might be very generous professors. You might get very good grades, so it's a very intransparent system. So, as a matter of fact, the universities do have the freedom to grant degrees on those students who pass the first state exam, and everybody in fact does it. So once you pass the first state exam, you will get a Magister Juris, but it's a piece of paper which serves nothing. What you need is the first state exam. But the universities do have the freedom to grant these diplomas or whatever they may call it. There are, for the sake of completeness, other law degrees. There are universities of applied science in Germany, very many, and they are quite good. But what they do will not grant their students the state exam, and they will not exceed the legal professions. What they will get with their bachelor's or master's degree, it's mostly economic law or specialized areas of economic law. They can work in banks or in insurance companies, or they can do accounting or whatever. or they work as paralegals in the big law firms, but they can never be attorneys, they can never be judges. So this is, in the eyes of the law faculties, second-class legal education, and we're a bit arrogant because they are very good lawyers, but what they are not full jurists, so they don't receive the second state exam. What we also have is LLM programs, and that's of course familiar to you. The LLM is, I would say, an American invention, or an Anglo-American invention, and our students increasingly go to the States or to England, mostly these two countries, to receive an LLM. And this is, for the big law firms, a very important factor. So they ask you, the big law firms would ask you either to have a doctorate or an LLM from a prestigious US or English university as an additional qualification. So many of our students go abroad, while German universities rarely have LLM programs. They sometimes have LLM programs in specialized areas like tax law or IP law, but this is less prestigious to have such an LLM than an LLM in a US university. And the point in having an LLM is not so much the point in having knowledge about US law, but to have knowledge in the English language, proficiency in English language. That's the main point. Just a brief word on the second part of the legal education, the so-called Referendariat. That's a practical legal training. It's mandatory, as I said. It takes about 2 years to complete it. And at the end of this period, you will visit in between all the different areas of law. You will be a clerk and a judge. Then you will go to the prosecution and so forth. And at the end, you will sit the second state exam, which is entirely administered by the state, the federal state. Again, 16 different systems, and this has nothing to do with university education. That's over after the first state exam. And then, once we have the second state exam, again, you have to write a number of written exams. You can practice as an attorney, Rechtsanwalt, or be a judge, or be an administrative lawyer, and without it, again, you are not. So the Einheitsjurist is the role model, and when I look around to other countries, I think not very many countries do have this restrictive approach to the legal profession. Mostly the model will be you do a bachelor degree or master's degree, and then you choose what you want to have as a career track, and then if you want to be an attorney, you go to some special school for attorneys for a year or so, and then afterwards you get your diploma, or you get it even before. But this very demanding, very long education takes 7 years or so to complete. That's, I think, typical for Germany. Right. Now you have an impression of the legal education in Germany, the overall idea, and now I'll get into the details. What do you have to study and how do we teach law? What is the idea behind this Einheitsjurist Ausbildung? How do we transpose this into practice? An example from my federal state, Baden-Württemberg, the contents of the study program, that's in the section of the Justizausbildungsprüfungsordnung. You see what we expect from the students. It sounds quite harmless. Students should deal with the most important areas of civil law, criminal law, and public law, as well as with a focus area, that's a bad translation, Schwerpunktbereich, in each case including references to international, in particular European law, as well as procedural law. And I'm looking to Alvaro because procedural law is a bit underrated here. Alvaro told me that here in Peru, or at the Católica, you will have very many courses in civil procedure, while in Germany it's only quite marginal. It's the last in the line, as well as procedural law. And the excuse, it's really an excuse I would present to you is procedural law is very important in the second part of legal education, in the Referendariat. where you will do procedural law in all three areas: civil law, administrative law, and criminal law. Basic subjects, so Grundlagenfächer, history, philosophy, sociology of law, comparative law, and so forth, are to be taken into account appropriately. That's, I would say, also a difference to other systems, and I gather also the Peruvian system. Those subjects, so history, philosophy of law in particular, or Roman law in Germany, they do not play a role in the state exam, not really. Maybe, you know, sometimes when you interpret a piece of legislation because you need it for your Sachverhalt, then you take into account the history of this legal institution. But you will not be asked to write something about the institutions of Justinian. That's nothing you will ever be asked in the state exam. And because there is no demand for that, the students will not be interested in the first place. And this is reflected here, are to be taken into account appropriately. So it's also something you maybe put less interest into. The most important thing you have to learn is civil law, criminal law, and public law, and this is where the exams will be placed. The most important means within the syllabus is the Klausur, the exam, the written exam. In Germany, almost entirely we place our confidence into the Klausur, so the written exam paper, and the final exams consist, in Baden-Württemberg at least, of 6 exam papers of 5 hours each, to be written in a very short period of 2 weeks. So within 2 weeks, you write 6 exam papers. It's physically demanding, and it's of course demanding because in these 2 weeks at the end of your studies, you will be asked to know everything you have learned in those 4 to 5 years before. You cannot learn Roman law and then forget about it. You learn Roman, that's a bad example. Let's say civil law, the general part, which you will be learning in the first semester. You cannot sit the exam and forget about it. You have to keep it boiling until year 5 when you sit the final exam. Quite demanding, but once you're through, you will never ever forget these subjects. So it's a two-sided coin, really. What you may use in the exam is, those of you who have been to Germany know it, this red brick. Usually, it used to be called Schönfelder, and they have changed the name to Habersack. Schönfelder was, well, it seems in the Third Reich a Nazi lawyer, so they dropped the name. They also dropped the name of the famous Parland commentary to the BGB, because Parland was also a Nazi lawyer, and it's called Grüneberg now, but the content is the same. So you can use this collection of laws in Germany, of acts, but you may not use anything else for civil law. For public law, criminal law, there are other collections of law. And with this and your brains, you will be asked to solve cases, Fälle. And what we do in Germany really in legal education is Fälle lösen, solving cases all the time. You will be given fictitious cases, and you have to solve them. And the method to solve these cases is called Gutachtenstil. And the result, the product of your efforts is the Gutachten. So the entire legal education circles around these fictitious cases. Sometimes they're not even fictitious, they are built according to landmark cases or whatever. And you're asked to solve them in a distinct style, which is called Gutachtenstil. So it's a very practical approach, really. It's not very theoretical. We don't want you to dwell on legal theories or so. A theoretical approach is only a means you would need to interpret the law, and which will then help you to solve the case. So it's a very practical approach. Now, the objective of the exam, of the Klausur, is the following. We want the students to develop an ability to solve a legal case by applying the Gutachtenstil and using a scholarly working technique. So we are a university, we're universities, that's a scientific education after all, so we want them to work in a scholarly manner. What we see when we read these Klausuren, these Gutachten, we really see if somebody is able to discuss essential problems within the limited amount of time. 5 hours sounds long, sometimes it can be very long when you don't have the clue, but it's very limited, and in 5 hours it shows where you place the effort, what is, you know, the idea of the case, where does the case run. So you see very much in this Gutachten in 5 hours. Work efficiency, that's the main point. You cannot come to every problem in the Sachverhalt, but later in practice when you work, you have all the time, or all day and all night if you like, but you have only a limited ability to work on one particular case. So within these Klausuren, we train students to work efficiently. We want them to identify those areas in the cases which are problematic and put much effort in these areas and less effort in other areas. Now, a practical guide to the Klausur consists of 4 phases. That's at least how I tell my students to write a good exam. And the first phase would consist in identifying the facts. So what you get when the exam starts is the Sachverhalt, so the fictitious case. And sometimes a fictitious case is just a few lines, sometimes it's 2 pages or 3 pages. In the second stage exam it can be 10 pages or 15 pages. And the first thing you have to do is read the text and read it again and read it again. You have to know it by heart. You have to know exactly what happens. And the good thing is, those things who are in the Sachverhalt happen and nothing else is important. You cannot interpret the case. The case is as it is described on the piece of paper. What you then do is filter already a bit from this fictitious case, who is acting and what do they want. So the first step is already to draw a sketch. So you've got persons, they're usually called A and B, or C and D, or X and Y. Sometimes they have names, Hans, Peter, Fritz, but we call them H for Hans, F for Fritz, and so forth, to shorten the solution. And we usually have these little sketches with lines between the persons to illustrate legal relationships. Who wants what from whom? And then you look at the questions posed to you, and accordingly you will have a first idea of what the case is all about. And sometimes at the end of the fictitious case you will have concrete questions like, can A demand from B to give back the watch he took? Very simple, very straightforward. Does X have a claim against Y for payment of 10,000 euro? Very straightforward. But sometimes you have general questions like, what is the legal situation? For those of you who have been to Germany, was ist die Rechtslage? These are more difficult because you have to interpret the question in the first place. Wie ist die Rechtslage? What is the legal situation? Implies an interpretation of what the parties really want or would want. And sometimes you are given hints in the Sachverhalt, sometimes not even this. This is given, so you have to interpret the idea of the parties of the case at hand. And again, how the students approach these questions shows in how far they are able to think economically, efficiently, and in a legally viable manner. Now this is an example. It's a real case and fictitious at the same time. It's a case decided by the Bundesgerichtshof a couple of years ago, and it's a bit simplified, of course, but it shows how a legal case, a real legal case, is to be transformed into a fictitious case very easily. I call it Siberian method because, well, you will see why. It's a case where somebody rented an exhibition center, or inside the exhibition center he rented a cafe or a restaurant, and he was obliged to run the restaurant. And the landlord, he's called V, Vermieter, landlord, he asks, of course, monthly payments, monthly rent. So as M and the restaurant is not running very well, M is in financial difficulties, he cannot pay, and he stops at first to pay the ancillary costs, so costs for water and electricity and so forth, and then at some point stops paying the monthly rent. And now comes the Siberian method. M's restaurant is supplied with hot water and heating power by V directly. So he doesn't get the electricity and the energy from a supplier, a third person, but from the proprietor of the exhibition center. So V just stops the supply and puts, of course, pressure on M to pay the rent. And as M continues not to pay the rent, V terminates the contract in September 2022 and initiates eviction proceedings, so it tries to kick him out. It will take a while, for V it's very clear, it will take a while to kick him out, and so he still hopes that there will be some money coming in. Now the winter is drawing close, and in Germany this is an issue. Winters can be cold, and it is quite clear, without hot water, without electricity, without heating, there will be no restaurant in the winter. Nobody will come to a restaurant which is cold, right? So now M wants to know whether he has a claim against V to supply him with hot water and heating. This is the exam question. It's type 1, so to say, it's a concrete question. Does M have a claim against V to supply him with hot water and heating? And what we ask from our students is to answer only this question. If somebody talks about anything else, this will not count, and it will show how the student is not able to directly answer what he is being asked. So he will maybe even fail if he doesn't answer precisely this question. Okay, this is the Sachverhalt, and we have a bit, in this case, it's quite easy. We have only two persons. The sketch would be straightforward. There would be V, and then there would be M, and you would write lease contract on the line between the two persons to signify that there is a contract between the parties. The second phase of this Gutachten consists in outlining the solution. We call it Gliederung, so it consists of, I'll show you the example in a second, consists of very sketchy sentences, and you identify the key problem areas. So we ask our students to identify in this first phase is what we call Anspruchsgrundlagen. We think in German civil law, we think in categories we call Ansprüche, claims. And Anspruchsgrundlagen is the legal basis for the claim. So, provided here that M wants something against V, he needs a legal basis for the claim, and the legal basis is called Anspruchsgrundlage. So, you will always start out with a legal basis for the claim. And in many cases, there are more legal basis for the claim, or possible basis for the claim. And what you will do in the Gutachten is to evaluate the viability of these claims, one after the other. And in the outline, we recommend this scheme A1, 1A, and so forth, to identify different levels of argumentation. And this would be an example for this case. This is the sketch. So you see, in the solution, you would have three possible bases of the claim, three Anspruchsgrundlagen. So the first idea is that the claim of M could be well-founded under the lease agreement. So provided you have a lease agreement, M could argue, and in the lease agreement, there was an agreement also on the supply with electricity and water and so forth. There is a claim of M against V of supply with just that. Then, of course, we have to argue whether or not the expiry of the claim because of the termination of the agreement, will end this claim. In this case, you will not really go into detail, you will just think of the different aspects of the termination, and you will probably notice at that stage already that a terminated lease contract can never be the basis for such a claim, because it's terminated, right? And this brings you to the next possible basis of the claim, and it's called, and we use Latin phrases, culpa post contractum finitum. So the lease contract may be terminated, but it still may have effects post contractum finitum, so after the contract has been finished. That's possible. But never at no place in the BGB will you find an official, an explicit legal basis for that. So you look for an alternative, and it's the Treu und Glauben principle in paragraph 242, so bonus mores, and there you would have to interpret this paragraph, and you would use the methods of interpretation of this paragraph, and you would try to interpret whether or not this might be the basis of such post-contractual duties. You might come to the result that there is no such duty, because it's a very one-sided story here. M has done nothing to fulfill the contract, so he has been acting negligently in not paying the rent, and under the principle of buenos mores, it's difficult to give you a right when you have yourself acted culpably. And this brings you to the third basis of the claim. It's in German law called interference with possession. So M is the possessor of this premise, and as the possessor, it could be that B interfered with it. So even though he is the proprietor, he must not interfere with the possession of the other party in a way which is not allowed by the law. And you could argue, and this is the most interesting part of this case, whether or not this protection of the possession gives a legal title also for the service, supply of energy, supply of electricity, and so forth. In the end, the result could be that M does not have a claim. Or the result could be that he has a claim under one of these Anspruchsgrundlagen, or under 2 or under 3. And we always teach our students that it doesn't matter to which result you will get at the end of the day. But what matters is with which arguments you reach your result. You have to be precise about the arguments which lead to a result. And if you have good arguments, but in the end you get it wrong, that's not so difficult. That's not a story which makes you fail the clausur. The arguments count, right? So if you end up in phase 2 with this sketch, it's almost done. The story is almost over. All you have to do now is write the entire solution. And if you look at the time you need for each phase, the third phase, the writing of the Gutachten, will consume the most of the time, 60 to 70%. And what the students will need to develop is a routine at what point in time you have to start writing the actual clausur before you get really nervous because you won't end. We still write with our pencils, paper pencil, that will change. I don't know how about your exams in Peru. We're very slow in digitizing our legal education. I would say in 5 years or so we'll have digital exams, but at the moment we write it with our pencils on papers, and this results of course in very illegible exam papers sometimes because people are stressed and write very quickly. So we always teach them, please write neatly. Now, this is an example of the Gutachtenstil. I come back to the style itself, but these are the examples, and you will recognize this is exactly the first paragraph here, and this is how it would read. And you will notice that it's
a very distinct style. You start with M could have a claim against B to prohibit the threatened supply cut off under the lease agreement. M könnte einen Anspruch haben. You don't say, hat einen Anspruch, könnte einen haben. This is a hypothesis. The first thing you do in the Gutachten is to place a hypothesis. Possibly he could have this claim. And then you try to prove that there is such claim, or you try to prove that there is no such claim. Next sentence, for this to happen, a tenancy agreement would first have to effectively exist and continue to exist. Step by step, you go through the different aspects of this Anspruchsgrundlage, and the first aspect would be to have a lease agreement in the first place. This is not problematic in the case. The Sachverhalt doesn't really say something about it, so you can imply that there is such an agreement, and you will just write a few sentences that there is an agreement between the parties, and that this agreement also complies the supply of heating power and hot water. Second, more interesting part would then be the expiry of this lease contract because of the termination. In the end, it's also not very difficult. There was a termination, it's just a question of what kind of termination, under which paragraph, and you will solve that in no time. And you see, it's very well structured. You have these little paragraphs all the time, and within each paragraph you have one argument. So we train them to distinguish the arguments and the level of the argumentation. If you have a sub-argument, you use these little letters, double A, double B, double C, and so forth. And of course, we're imitating here our courts. So if you read a judgment of the Bundesgerichtshof, that would be exactly the same. Phase 4, completing the work, the last 5 minutes or so, you will reserve for a last check of formalities and so forth. This is an example how the papers look like. Well, it's a good example. Most of them don't look that neat. You see at the left-hand side there is a margin which is open for the correction. And indeed, I'll have a slide on the correction, on the examiner's perspective as well. We write on the margin our comments. So we say this is wrong, this is ill-founded, there is an omission and so forth. So we do correct very thoroughly. Now very briefly on the Gutachtentechnik. The Gutachten, expert opinion, I don't know, this is not a very good translation, but it's the only one I could think of. It will contain the discussion of all legal questions raised by the facts of the case, everything. So you have to be comprehensive. On the other hand, you will not use arguments which are irrelevant for the case. You will not have a legal discourse on something which is not raised by the facts of the case. So be precise. Find the pertinent legal issues. Sometimes it's only one or two issues, sometimes it's many more. Clarity in argument. Don't have any discourse which is not induced by the case. Der Sachverhalt, the facts of the case. As I said, you have to imply that the facts of the case are there on your paper. You cannot interpret the facts of the case in a sense that you invent something which is not there. Sometimes there are gaps. The gaps could be the result of a mistake of the examiner. He could have omitted something, that happens. And sometimes in the exam, somebody raises their hand and says, I'm sorry, it's not possible to solve the case because there is this and that information missing. That is quite rare, but it happens. Sometimes there is a gap which has to be filled by what we call der gesunde Menschenverstand. So what is deemed to be, just rational and normal, and this is of course allowed. So things which would happen in the normal course of things can be interpreted like that. But don't invent stories. And sometimes students invent stories because they know the solution to this fictitious variant of the case, but not to the one on the paper. So we tell them not to do that. And this is, of course, a big difference to real life. An attorney can ask his client, to supply more information on the case. And in fact, most of the time in real life for the attorneys will be devoted to that, fact-finding. In university, we don't have time for that. We provide the facts. So students must stick to those facts, given them in the Sachverhalt. Sometimes in the Sachverhalt we have very, well, awkwardly formulated legal opinions. So in that case, M or B could mention this and that argument. Sometimes this could be a hint. Sometimes it could be a dead end, a pitfall. So sometimes it's not sadistic, but sometimes we push students into a direction which is a dead end, and we want them to find out very quickly that this is a dead end. It shows then if you are able to find out these pitfalls. The Gutachten should be precise, should be short and concise. You don't use arguments which are not necessary to solve the case. We don't want to read legal arguments at length on issues which are not relevant. Sometimes students tend to tell us things which they know, but which are not fact-related. So it's just, we have these scribbled lines, we say irrelevant, irrelevant, irrelevant. And then out of 10 pages or 20, if 5 are relevant, you will probably fail. So this is one of the main qualifications of our students, to see what is relevant for the solution of the case and what is not. It should always be the law which is the starting point. So we tell them, look into the law itself. Even if you think you know exactly paragraph X, Y, Z, read it again and again and again, and you will find maybe a different wording from what you have in your mind. And this is why we tell them, we allow them to use the law in the exams. They can read the BGB, they don't have to read it, know it by heart. We always want them to quote the provisions which are pertinent. So as we have seen, there were always quotes of these legal norms. So we want them to state what the legal basis is for their argument. The style of the Gutachten, Justitiologismus it is called, it goes back really to the Aristotelian logic. Because the law, the legal norms are usually built like that. If A, then B. That's the logic of a legal norm. If you damage something, you have to pay. And in the logic of that, our Gutachten is built, and this is why we have these hypotheses. If A, then B. You hypothesize that if there were A, then there would be B. And if there is A, you will find out in due course. So first, the Obersatz, the hypothesis, is formulated as a hypothesis. A could have a claim, right? And then step by step you go through, and the most important part is what we call subsumption. So you merge the facts and the law. One side is the facts, the given facts, the other side is the law, and the subsumption means to bring together those two levels. And this is where most students have difficulties. They usually jump to conclusions, they say this is the law, and this is why, and this is the facts, and this is why there is this claim. Usually the subsumption is underdeveloped. And then if you arrive at a result, you have the conclusion, it follows that A and B have concluded a contract and so forth, and at the very end you have the final result. So you should be able to start from the Obersatz, you could have a claim, and then go to the result, and the result should echo, of course, the hypothesis. In the second part of the legal interpretation, what we have is the Urteilsstil, and also the judges would use that. They would start with the result. M has a claim against B. Because, and then comes the arguments. We have had a discourse about the argumentation in judgments this morning. That's quite important. And this is what the students then learn in the second part of the legal education, not in the first. Anschlussaufbau. I'll skip that, I've had that already. Very briefly at the end, the examiner's perspective. So the professors will mark the exams in the state exam. Even though it's a state-run exam, the university professors will at least partly, so 50% more or less, will be marked by the professors, mark those exam papers. During the studies, the assistants, or doctoral students mostly, will pre-mark the exam papers. And of course, they have a big pile of these papers, and they will use, I don't know, 30 minutes per exam. And of course, it's a very quick and dirty method. You go through and say wrong, wrong, right, right. In the final exam, we devote more time, of course, to that. It will take me an hour or so to read an exam paper in the state exam. But still, if you have a bad style, it will show immediately. So it's important to be clear, have good arguments. Right, so the last part, and it's only this slide really, is about the future and the shortcomings of our legal education. Well, first shortcoming, I would say, having been abroad, is the lack of oral skills. We overtrain our students in written skills. They all, at the end of their studies, are able to write those Gutachten. They think in these Gutachten. There is a joke between the students. At the end of their studies, they would talk in these hypotheses. Possibly we could go to the cafeteria like that. So we over-educate them when it comes to written skills. We do not have very many oral exams in the studies. And this is a skill which is lacking when they get to the practice. In England, in the States, students have much more oral exams than written exams. So what they are able to do is present arguments in an oral debate. So I've been to the Oxford Union, a very impressive debating society. The question would be, do we want death penalty or not, right? So any students present in the Oxford Union would be able to have a discourse of 2 minutes on the question of whether or not the death penalty should be kept or abolished, with clear arguments and a viable solution, be it wrong or not. A German student would need, I don't know, 5 hours or a day to prepare and then come up with a treatise of 10 pages, but would not be able, I would say, on average, to present it in 2 minutes. So I think we should focus more on oral skills. Second shortcoming, I've mentioned it briefly, we are very analogous, so to say, in our education, in a very mechanical way, so the exam papers are still pencil and paper exams. We will need to speed up our digitization, and with that, I think we can change also a bit the approach towards our exam. Also, when it comes to the content, digitization is not yet everywhere in the legal education. We still have these cases like the case I showed you, and the digital world is a bit underdeveloped in our legal education. Lack of interdisciplinarity. We are lawyers, we are Volljuristen, and we don't look left and we don't look right. The basic foundations of our legal system, philosophical, historical, and so forth, the comparative aspect is underdeveloped because it doesn't have a proper place in the final state exam. How would you write a Gutachten on questions of Roman law? It's impossible. There was an effort at some point to have a focus on that, and it resulted in what's called a Märchenklausur, so a fairy tale exam. It's of course pejorative as a term. There could be questions like, describe the development of culpa in contrahendo from Roman law to the present days. And then you would write a paper on what you know about the culpa in contrahendo in Roman law and in the present days. It would not be a good argument. So the students were afraid of these papers, while I think they would be quite easy, because it's just a well-structured paper on what you know, what you've learned on the Culpa y Contrato. But this has disappeared. So we do not have any means to ask the students to be interested in other subjects. It's not interesting for them because it doesn't appear in the exam. Fourth point, the stress. I told you the state exam comes at the very end, after 4 to 5 years. And this is what counts. So if you fail, 4 to 5 years are down the drains. 4 to 5 years are useless. You will have a second chance. If you fail again, 6 years will be down the drains. So I think this is a difficult way to administer things. And as we have high rates of dropouts, it's very difficult studies. We think, at least my university and a few others as well, to have an LLB, a legal bachelor, as a solution. So we think that it's a good way to reduce stress, to give the students after 3.5 years an LLB, so that when they fail the state exam, they would still have a degree which would not allow them to exceed the legal profession, but a degree which would allow them to be, I don't know, an accountant or whatever, paralegal or whatever. And what is more important, reduce the stress before they go to the state exam. Right, so you see, it's a distinct legal education with distinct problems, and I'm happy to have your questions and discussion. Thank you very much.